Welcome to the Alliance Alumni Webinar Series. It has been forever since we had one, and for that, I profusely apologize. We shall strive to be much better in 2026 and have them more regularly. For 2025, what better way to end the year than having Victoria Wambui back with us to give an updated presentation on family trusts, family wealth management. I will let her introduce herself and go on with the presentation. Feel free to ask your questions on the chat. I will be monitoring that, and then at the end of the presentation, I'll read them out for Wambui to respond to them. Karibu sana, Wambui, the floor is yours.
Okay. Hello, everybody. My name is Victoria Wambui. Thank you very much for joining us. Thank you, Eric, for having me and for having me again. It's quite an honor. Yeah, so let's just go right into it. So today we're going to look at family trusts as a mode of, as one of the ways that you can manage your family wealth. I'm going to keep it quite short, and I'm not going to cover everything with regard to family trust. I'm literally just going to cover the things that tend to crop up quite a lot in practice and people that Kenyans tend to be interested in. So if you have the screen in front of you, these are the topics we're going to look at. So you know about the adage, from rags to riches to rags in 3 generations. So we're going to look at why that's the case, a short definition of family trusts, the law underpinning family trusts, and then we're going to see, basically try to show you why it is that it is necessary to set up a family trust in Kenya. And then we're going to look at family trust and divorce, and family trusts with regard to foreign ownership. These are quite interesting ones because people tend to ask that and what. So I thought it would be interesting to go into it because, it's quite informative. And then I'm going to look at living family trusts. There are only 2 of them. There are very many types of trusts, but for the sake of this presentation and for the sake of what tends to interest people more, that's what we're going to look at today. And actually, of the 2, I'm only going to just go into detail about the revocable living family trust. And then we're going to look at a short case study of the Jenga Karume Trust, which, was a big deal. It was a very long, sort of protracted and acrimonious court case about it. Okay, so let's go into it. So the Family Business Institute says that only 33% of family-owned businesses are usually passed on to the 2nd generation. And then of that, only 12% go into the 3rd generation, and then just 3% go into the 4th generation. So it tends to be that the 1st generation makes a lot of effort, comes up with all of these businesses, makes a very good, has a very good run, and then things kind of go down after that. So the reason why this is that generally, businesses, people who come up with big businesses, we have very many examples in Kenya. We have your Nakumats, we have your Taskers. And so the reason is that usually there's not a very well-founded or well-defined family vision and values and goals and financial objectives. Usually the founders don't really take time to sort of educate the successors in the line of the family business, or even to kind of give them a stake in the business. That tends to, work against the business long term. And then that's the same thing. You don't involve the next generation. You don't educate them. Then it means that once you're gone, there's really nobody to take over and to sort of like keep the family wealth going. And then also there's a way that, especially in Africa, we don't really engage professional advisors. We think we can just go ahead and do it ourselves, or even enhance accountability and governance. We have sort of learned though from these failures with recently with companies like Naivas, where they sell part of their equity to private equity firms, and then they're able to get accountability and governance, which means it's not just a family business, but you're able to get professional help, which obviously makes things easier and better. The other thing is that people don't tend to address internal family disputes, as well as the sort of like financial side of things. So it could be that the business is actually doing very well, but internally you have a lot of disputes and acrimony. And so we have examples of families who have learned that you need to work on the interpersonal family relationships as well as the business side of things. Because if if people don't like each other, then it means that they probably don't want to really work together, and they're only looking out for their own personal interests as opposed to the interests of the entire family. Okay, and then we know for a fact that things like divorce, bad investment decisions, excessive spending, they're not good for long-term preservation of family wealth. And then again, lack of estate planning, and that is what we're going to try and look at today. That's what we're going to kind of try and solve today. Okay, all right. So a family trust is a legal entity where a person can transfer their assets to be managed and administered by the trustees on behalf of the chosen beneficiaries. So it means that whatever it is that you have in terms of your properties, your shares, and things like that, you're able to transfer them into this family trust where you basically have you decide, you determine how much control you will have afterwards. So the assets usually can include things like land in your estates, your company, business shares, rental income, stocks, cash investments, family heirlooms, and intellectual property. So I'm going to now get a little bit technical. So for that reason, I kind of thought to give you the definitions of some of these legal terms moving forward. So in this case, a settlor will be the person who creates a family trust. So it's basically the person who whose property, whose assets, whose wealth is going to go into this family trust and be transferred into it. So the settlor usually is in a very powerful position because they can determine many things. They can determine, for example, what kind of trust they're going to form. They can determine the powers of the trustees. They can determine who the beneficiaries are going to be. So that's quite key. Then the trustees are the individuals who will then be able to manage this trust. So we can have sort of private individuals, your family, friends, your family and your friends, or you can have now what we call corporate trustees. We have companies like ICEA, Lion Group, the NCBA Group, PLC, Standard Chartered Bank, and they can be able to take your wealth, your money, and be a trustee over it for the sake of your beneficiaries. So the beneficiaries are the individuals of the groups who will benefit from the trusts. So usually they're typically relatives, but they can be other people as well. And now under the new law, we have what we call an enforcer. An enforcer is the person who's going to basically be looking, basically monitoring what is happening in the trust. Because in the past, it's been said that trustees have too much power, and sometimes they, go off the tracks, and they're not really running the trusts for the benefit of the beneficiaries. So now the enforcer is the person who's going to be looking at the books, and ensuring that the trustees are doing the right thing. They're not squandering the trust wealth and trust property. Okay, then we have the trust deed. So the trust deed is a very key document because it's a contract where the settlor is going to put all of these things in writing, basically. So it's going to show the terms, the powers of the trustees, the powers of even the settlor himself, any responsibilities, the goals of the trust, who the money goes to. Does it go to only grandchildren, great-grandchildren? Who does it go to? How? Is it only for education or for hospital bills? So the trust deed, it can be as wide as you want. And the good thing is that the courts have been very shy in terms of interfering in what is in the trust deed. So when you want to go for the trust deed, when you're drafting a trust deed, it's first of all good to get obviously someone who knows what they're doing in terms of legally, a good lawyer, a competent lawyer. But also it means that because once the trust deed has been done, you're locked in. It's really the constitution of the trust. So you cannot really be able to have wiggle room. If it's not in the trust deed, then it's not going to be implemented in terms of how the trust works. Okay, so now let's look at the law. So the law with regard to family trust is basically directed by the Trustees Perpetual Succession Act, Amendment Act of 2021. So it introduced the idea of registration of trusts, and it allowed for trusts now to be used as personal estate planning, or with the aim of preserving wealth for generations and generations to come. And then it allowed for perpetual succession, which means that family trust now can continue indefinitely. When you register and then incorporate your family trusts, it will be there for generations, for very many, many years to come. And it's not as limited as a will would be, for example. Okay, and as I said, it created the role of the enforcer to ensure that they're able to keep the trustees and the management of the trust accountable. All right, and then now we have the Finance Act of 2021. One of the biggest advantages of having a trust is that there's so many tax exemptions, and the main one, I think there are about 4 of them. So the first one is that under the Finance Act of 2021, the stamp duty tax, trusts are exempted from stamp duty tax. So with regard to transfer of properties to a registered trust, or even when it is a transfer of property from the trust into one of the beneficiaries, if it's sole ownership. So that means that when you've put your property into the trust and it's registered, then you're exempt from stamp duty trust. It's a very big one. People like that. So it's one of the reasons why you want to do this, to go ahead and register your trust. Okay. Then secondly, you have the income tax exemptions under the Finance Act 2021. So the principal amount and any sums that go into the trust, they're going to be exempt from income tax, which is a good one. There's also exemption from capital gains tax related to the transfer of any movable properties that is registered into the trust. That is also exempt under the 2021 bill. The Finance Act of 2024 tried to sort of scrap these exemptions. It's one of the reasons why, it's opposed to all those protests last year. But, luckily, those are not, put in place. So it means that we still have the 2021 tax exemptions in place, which is a very good thing. Okay, sorry, where am I? Okay, then now we have this new proposed bill that's called the Trust Administration Bill of 2025. And this bill has a couple of proposals, basically to reform the law. And it's asking for the licensing of professional trustees, which means if you do choose to have a professional trustee, a corporate trustee, as opposed to just your friend or your family friend or your neighbor or something, it means that you can now have the option of getting the professional trustee, but they have to be licensed, which means now there'll be a degree of regulation and oversight with regard to professional trustees. And then it also asks for mandatory beneficial ownership disclosure. So you do have to now, if these reforms go through, they'll require for people to disclose who the beneficiaries are. And there'll be a register for beneficial owners, a bit like the companies. So they're trying to kind of have a bit more tight regulation and oversight. And then they're trying to consolidate all the laws with regard to trust laws to now come under this Trust Administration Bill of 2025. Okay, that's enough law. So why do you want to have a family trust as opposed to, say, just having your will and then getting it all done and dusted? So one of the things with family trust is that it helps with your wealth preservation. It holds and protects and shields your assets. And then it means that there will be no fragmentation, for example, of any property that you have. There will be no mismanagement of the property that you have. All the property stays within the trust. It is being managed. The trustees are investing for the trust, and there's income that's coming into the trust, and only the income and the proceeds of the whatever assets there are or shares are going to be then passed on to the beneficiaries. So you do get to preserve whatever wealth you have. As I said, again, there's no fragmentation, there's no mismanagement, which is a really good thing. Okay. It also means that once the settler has died, once the person who formed the trust has died, it means that everything can move on in a confidential and smooth manner. Because usually what happens is that if you don't have a trust, if you have a will or you don't have a will, then everything has to go through the probate and administration court process. And that can be long, it can be quite acrimonious. We know of many court cases where it's kind of gone on for 10, 15, 20 years. It also means that your will can be challenged and trust cannot be challenged. The courts have really kind of shied away from ever interfering with trusts. So it means that when you have a trust, you know for sure that what it is that you've determined with regard to your trust, it is what is actually going to happen, how you're going to have your properties sort of distributed and the income distributed. But if you don't have a trust and you just have a will, or you go without your will, and then then the court really just has to ensure really step in and arbitrate between all the different factions of the family to decide who gets what. that can be difficult. So the good thing with the trust is that it's going to be confidential, it's going to be smooth. You don't have to go through the court process. It's just very kind of smooth sailing. Okay, as we said just now, there's a tax efficiency, but also there's the issue of the beneficiary income. Any income up to 10 million, any income up to 10 million for a single beneficiary during a single year is usually not taxed. It's free from income tax and capital gains tax. So that's a good thing. So any income that is coming from the trust to a beneficiary up to 10 million is capital gains tax free, is income tax free, which is a good thing. Okay, then there's the issue of asset protection. We're going to talk about divorce in a minute. Now, with asset protection, with divorce, for example, any property that's put into a trust is never usually touched during divorce proceedings. We're going to talk about that in a minute. Asset protection also means that your any property, any wealth that's inside the trust will not be taken by creditors. It will not be subjected to any bankruptcy proceedings. And then if there are any legal judgments against beneficiaries where they are now the judgment debtor, they cannot be able to come into the trust to get wealth or property for the beneficiary. So really, it's very watertight. No amount of no divorce can be able to claim anything that's in the trust. No creditors can be able to do that. No judgment debtors can be able to kind of come into the trust pot to get anything, any wealth or money from it. So that's very good. Okay. As I said earlier, there's immediate continuity immediately after the death of the settler. So you don't have to worry about going into a public court battle. There's a lot of confidentiality with regard to how you distribute your assets, because it means that you get to decide what happens before even the settler gets to decide what happens before they pass away. And nobody needs to know what happens, what's going on in the trust. It's a very different scenario with regard to wills, because as I said, it's a very public process. Okay, then there's control. As we said earlier, the settler really does have so much control as to what happens with regard to the trust. They decide whether, the kind of trust that they're going to go into, they decide the powers that the different trustees have, they decide who gets money, and even if they decide, they decide that certain people can't get any income or benefit from the trust, then that is it. That is it. Nobody's ever going to be able to interfere with that. Okay. So upfront, trusts tend to be cheaper and simpler to set up than, as I say, the prorated administration control process. In the long term, you will have to think about things like, say, your tax, getting everything, all the paperwork in place. So the administration can be a bit. That is really one of the things that the trustee is going to be able to do in the long term. But at the upfront, it's going to be easier to do the trust, to cheaper and simpler, as I said, to set it up than it would be if you have to go to court, and you don't know how long that is probably going to take. Okay. Okay, so now we go to the fun part. So now let's talk about family trust and divorce. So we get a lot of questions about how you can be able to, be able to secure your properties and not worry that it's going to be part of the division of matrimonial property during a divorce. So Section 6.2 of the Matrimonial Property Act, it does explicitly state that trust property cannot form is not part of the matrimonial property, which means any property that you secure and you transfer into a trust will not be up for grabs during a divorce. So it's one of the legal ways that we can be able to shield division of property in your property during a divorce. But having said that, the settler, the person who determines what goes into the trust, the property that goes into the trust, or the assets and wealth, they can provide for the divorced spouses. They can determine explicitly that the spouse is going to get this or that, but it has to be explicitly written in the trust deed, as I said, in the contract of the trust that forms the trust. However, we can assume, strictly speaking, that if property is in a trust, a family trust, then it's not up for grabs during a divorce. Having said that, there have been a lot of challenges of what they call sham sham trust. So a lot of, unhappy spouses have gone to court to challenge the fact that, they probably want that property or this property, but it's inside a trust. So what we usually do when we're drafting this trust is we just put a couple of measures in place to ensure that the trust and the trust deed is watertight, so it cannot be challenged. And one of the things we do is that we ensure that it's registered. So you can be able to have a trust and a trust deed that's not registered. You can just have it registered under the Documents Act, but then you can have it incorporated, which is an extra sort of security measure, to ensure that the trust has been registered and it has its own legal, entity and a name of its own. We ensure that all the properties have been transferred from the settler and are now in the name of the trust. And we ensure that the settler cannot be said to still have so much control over what is already in the trust. Because if the court finds that, yes, you're claiming that you've transferred all of this property and wealth and assets into your trust, but still you have so much control, then they think that maybe this is just like a bit of a sham. You're just trying to, deny your spouse of certain assets and certain wealth. Okay. And then we ensure exclusion of properties. Yes. So under Matrimonial Property Act, this is what we say is a matrimonial property. So a matrimonial property usually is what is basically the primary property where the couple is living in, and this is what we call a contribution. So if the spouse made a direct contribution with regard to maybe even purchasing the property, or if they made indirect contributions, maybe they were digging the land, they were cleaning, they were taking care of the family, that can also be said to be a contribution. So you ensure that what it is that you put in the trust, there's no direct contribution from your spouse. That will help, because it means that if you're trying to kick out your spouse by transferring the property that where they actually live into the trust, and that's going to look a bit dubious. So we also exclude those properties where the spouse has not a direct contribution. Then we exclude the properties where that not commingled with other matrimonial assets. Ensure that there's a lot of paperwork, a lot of good trusts, and a lot of paperwork with regards to trust business. So once that is out of the place, it means that any other property you put in the trust, it will not be up for grabs during a divorce, which is actually it's a good measure to have. It means that now you can concentrate on the beneficiaries, and you don't have to worry about past or future spouses dipping into that. Okay. Right, here's the time, we're good for time. So now let's talk about foreign ownership of through family trusts. So strictly speaking, in Kenya, foreigners are not allowed to own any freehold land because that means perpetual permanent ownership, and foreigners are prohibited from owning agricultural land unless there's a presidential exemption, or they've been allowed directly by the government, or unless they buy shares in a public company that also owns agricultural land. So those two. So foreigners cannot own freehold land. Foreigners cannot own agricultural land. However, foreigners can own a leasehold land under the leasehold tenure for up to 99 years. And one of the things that we tell our clients when they come is you probably, if you want to secure your property in Kenya for your spouse, for your children who maybe are also Kenyan, it will be good to think about going for a trust. The reason we say this is because this is a caveat that we use. So strictly speaking, even if you set up a trust as a foreigner, you still have the limitation of the 99 years for your leasehold land. However, so you cannot bypass that. However, if you're the settler, if you're the person who owns the property and not the beneficiary of the property, then you can be able to have the land in the trust. You can be able to have a longer lease put into the trust. So as opposed to just the 99 one. So if you're the settler but you're not the beneficiary of the trust, or if you're just a trustee, but you're a foreigner, but you're not the beneficiary of this particular trust, then you'll be able to have a trust that can hold a longer lease. But if you are the beneficiary, then the lease is only going to be there for 99 years. It's still a good vehicle because it means you can still have all the benefits of having the trust. You're not going to have to go through probate. It's going to be very kind of quiet and private. when you pass on, you're able to determine who gets what and have a lot of control over your affairs in terms of wealth management. So we do recommend that people, the foreigners, also think about getting the family trust for the sake of managing their wealth. Okay, so now we're going to living trust. As I said earlier, I'm only going to look at the two living trusts because there are very many types of trusts. This is because this is what Kenyans tend to kind of want for themselves, because they kind of like to have a lot of control. So living trusts are created during the settler's lifetime. I say there are other trusts where you can create and they can come into place after you pass away, but these particular ones only they come into being, and they can be controlled during your lifetime. So the two that they have done are the revocable living trust and the irrevocable living trust. So with the revocable living trust, the settler retains the power to change, to amend, to cancel, and to the terms of the trust and the ownership of the assets during their lifetime. So this is why this is the favorite that most Kenyans will go for. They usually go for the revocable living trust because during their lifetime they can be able to have a lot of power and control. We do, however, say to people that the asset protection with this particular living trust is a little bit different. Is a little bit is not as high as it would be if the trust was irrevocable. So yeah, so you probably if you don't have problems with creditors, if you don't have problem with any sort of judgment debt, then this is a good one to go for. If you still want to have a lot of power and control and to be able to change and amend the terms of the trust, you want to be able to change and amend the beneficiaries, what the beneficiaries get, this is the one that you want to go for. That is the irrevocable living trust. So this one, once established, once you've signed the trust deed with all the terms and conditions, you cannot be able to change anything. It cannot be revoked by the settler. So at the moment that everything is, all the assets are transferred into the trust and signed away with the trust deed, the settler is locked out completely. They have no power whatsoever. They cannot be able to control anything. So most of now the power kind of goes to the trustees. But this one the courts really like because there's a lot of it's very watertight and people cannot be able to challenge. And also, as I said, it cannot be pierced by bankruptcy proceedings or divorce or any other potential lawsuits. Yeah, so that's good. So for purposes of this particular presentation, I'm going to look at the revocable living trust because it's the one that people tend to go for a lot. And a lot of questions tend to come out of these ones. So I thought this would be good, very informative for this particular presentation. So the revocable living trust, as I said, is operational during the lifetime of the settler. And the settler has very many powers. They have the power to amend and alter the terms of the trust. They have power to transfer the assets in and out of the trust. They have power to add new property and withdraw property if the trust deed allows. So very much depends on what is already in the trust deed. They have power to revoke and terminate and even dissolve the trust entirely. They have power to add new trustees or remove existing ones. They have powers to direct trustees, so they can be able to also control and manage the trustees as long as the trust remains revocable. And they also have the power to give directions on how the income and the assets are managed or distributed. So I know you can see why this is very attractive for many people, because it means that they don't feel like they transfer all their properties into this particular trust and then they're locked out entirely. So sometimes people like to have a lot of influence, still have some control. Yeah. So it can get a bit complicated as you'll see in a minute, but this is why this tends to be very attractive for people, the revocable family trust. Okay, so now the next question would be, if you're a settler in a revocable family trust, can you also be a trustee of the trust? So the answer is yes. However, the rule is that trustees are not allowed to benefit from the trust, because that kind of breaks fiduciary duties. So, sorry, what was that? Can the settler also be a trustee? The trustee, yes. So once the settler dies, it means that the trust is no longer irrevocable. Revocable, it becomes irrevocable. So let me repeat that. So yes, during the lifetime of a settler, the person who owns the trust property and then puts it in the trust, during their lifetime, they can also double up as a trustee. Yes, that is true. However, once they pass away, the trust no longer is irrevocable. The trust becomes irrevocable because now they no longer have any power there. Therefore, the power now kind of shifts to the trustees. Okay, I hope that's clear. So can the trust and the settler earn income from the trust? That's what I was saying earlier. So strictly speaking, the trustees are not allowed to earn income from a trust, because then it means that there'll be a conflict of interest. They're supposed to be there just to manage the trust, make sure it's very, it's making a lot of profit and having good income for the sake of the beneficiaries. So there'll be a bit of a conflict of interest if the trustees are also earning from the trust as well as the beneficiaries. So strictly speaking, they're not allowed to. However, as a settler, you're allowed to act as a trustee, but you cannot earn a trust income. What you can do is we can put provisions in the trust deed allowing you to have some kind of fee for your services and allowing you to be able to get your expenses reimbursed and your any fees that any kind of money that you spend with regard to the work of the trust, you can be able to get that reimbursed. However, you're not allowed, strictly speaking, you're not really allowed to have a trust income, because with regard to how the trusts are set up is such that trustees are just there to manage. They're not there to have any benefits, just there to be a manager, not there to sort of squander the trust, because it means that, then the interests of the beneficiaries are not being taken care of. Okay. So can the settler also be a beneficiary of the trust? That's another one, is a yes. And as I said, this is just really strictly for the revocable living family trust. So yes, you can be a settler, a trustee at the same time, and a beneficiary at the same time during your lifetime. So you can receive income from the trust, but again, as I said, that will have to be put down in the trust deed. If it's not in the trust deed, then yeah, it's not really allowed, strictly speaking, in the trust rules. So you can continue. People, this is a good one to take note of. People tend to wonder, after I put all of my family land in the trust, will I be able to even, live there? Will I be able to get an income from there? Yes, you can. If you go for the revocable living family trust, you can be able to still be, stay in your family land, get an income, but everything now will go through the trust as opposed to now just, your kind of personal private individual. Okay. So now, under revocable living trust, what you would ask are the powers of the trustees? Because as you see, the trust settler is still very big, is kind of looming large, and still has a lot of power and control. So the trustees, again, strictly speaking, are there to manage the property. If you do decide to go for a separate entity as a trustee, whether a private individual or corporate trustee, they still are able to hold and manage the property. They invest all the trust assets. We spoke about the shares, we spoke about the land. They're able to distribute they're expected to distribute the income and benefits to the beneficiaries and to transact with any third parties. So your professionals, your banks, the trustees are the ones who will deal with them. They maintain their trust records. And then they are also, allowed to appoint any agents that will help in the work of the trust. Okay, so you would ask, how do you go about, forming a trust? So the first step would be for us to draft your trust deed for you. We'll help with your appointment of your trustees, and help you think through whether you want to have a private trustees, whether you want friends and family members to be trustees, or whether you want to kind of go down the route of the corporate trustees, which can be a bit more expensive. But we'll ensure that, we'll tailor your trust deed to your particular needs. And then the second part is now to go about registering the trust deed under the Registration of Documents Act. That's the Register of Documents. So this doesn't take long, about 1 to 2 months, I think, that particular step. And then the third part, which sometimes people will go for or not, is the incorporation of the trust. But remember that if you want to enjoy all the tax breaks and all the perks and all the advantages of the trust, family trust, you really do want to have it registered and then incorporated. So that one it takes a little bit longer. It's under the Trustees Perpetual Succession Act. It takes about 2 to 4 months. So give or take, we should be able to have everything done between 3 to 6 months is the kind of timeline that we have for that. Okay, so I thought it would be good to have a case study that kind of helps you see how this works in Kenya. So you might all be familiar with Njeka Karume. He was a cabinet minister, and he had a very big sort of portfolio, a huge multi-billion empire. And when he did something very novel for his time. He formed a trust, and he got some very prominent people and family members and his friends to be trustees in the trust. So this particular trust was going to come into to sort of come into play once he'd sort of passed away. But what happened is that there was a court case. So the children, one part of the family was not really happy about how the trustees were running this particular trust. So they filed a case in court against the trustees. This is Albert Kigera Karume and 2 others, versus George Ngugi wa Ireland and 2 others, number 125 of 2015. So the beneficiaries had there were many things that they were not happy about. So one of the things they said was that the trust was not valid because it was very novel at the time. They were really just used to having wills. And they thought this particular thing is just difficult. They're not really, the trustees are kind of getting in the way of us being able to access these properties and this wealth. And it's a lot of wealth. It was about 40 billion at the time. So they say they sought to challenge the validity of the trust. And then they accuse the trustees of mismanaging the trust, selling off part of the trust property without any accountability at all. And this is the case that kind of led to the 2021 Act, so that now we have the enforcer that kind of looks and manages over, looks at, monitors what the trustees are doing. So as I said again, the beneficiaries were accusing trustees of mismanagement and of selling off the trust assets. They also felt that the trustees were keeping the beneficiaries in the dark. They were just doing things and not really being accountable as to what trustees were doing. They're not providing any financial accounts. So they're very unhappy about that. And they also say that they also accuse the trustees of neglecting the beneficiaries when they were having, financial problems. I remember a couple of family members were going to hospital and not being able to pay the hospital bills, and the trustees were not being able to provide this money. So, people are very aggrieved for that reason. That's why the case was filed in court. Okay. However, things didn't quite go how the beneficiaries were, hoped they would go. So the High Court in 2020 made this really huge landmark judgment. And really Justice Abrili, she said that, the trust was valid as a way of, family planning, your family estate, your wealth management is a valid instrument. That was not in doubt. So that really didn't go according to how the beneficiaries were thinking. So she also said that the courts would not interfere with how the trust deed has been drafted. And they said that the court would not alter or destroy a trust, but it would only uphold and protect it and ensure that the trustees were performing their duties. She also held that the trustees had failed in this particular case. They had failed to discharge their duties and remedy. But the remedy they had failed to discharge their duties, but the remedy was not to dissolve the trust in its entirety. They were not going to kind of throw the baby with the bathwater. They were going to, the remedy also was not going to be to give the beneficiaries the control over the trust, but the remedy would be to kind of replace and remove the trustees, and then ensure that the trustees are doing their job according to the trust deed. So again, the beneficiaries were disappointed because they really were hoping that the trustees would just be kicked out, the trust would be dissolved, and they'll be able to have more control. So the judge, Justice Roslyn Aborili, said that the trust is valid. They were not going to dissolve the trust. The beneficiaries were going to have to wait, and the trust was going to kind of have to replace and get new trustees, as long as that was within the mandate of the trust deed and the law. Okay, however, the judge did say the court did hold that trustees still have to be accountable. They do have to be accountable. They do have to kind of make an effort to have a good relationship with the beneficiaries, so that the beneficiaries can be confident that they're actually doing their job well. Okay, I think that's more or less done. So Yes, so I thought to just kind of go through very quickly, what it is that we can do for you with regard to establishing your family trust. As you can see, it's very beneficial. Um, um, so we are able to, at the law firm, we're able to give you consultation and legal advice. We're able to help you draft your trust deed. As you can see, there's so many pitfalls, and you do need a lot of legal expertise. So you need someone who's competent and knows what they're doing. We'll help with the transfer of your assets into the trust. We'll help with the appointment of your trustees, whether it's your private trustee or your corporate professional trustee. We'll help you think through the appointment of your enforcer. We'll help with the actual registration of the trust and you obtaining your trust PIN, KRA pins. And then afterwards, we'll help with regular reviews and updates. There's a lot of administration later on, not necessarily at the point of registration, but later. So there's a lot of paperwork that needs to be done. So we'll help with that. Yes, so I think that's that. Yeah, I think we can ask the questions now, Eric. Are there any?
So far, I have one question. You may have touched on it, but maybe you can expound on it. Purity is asking, how does one pick trustees and two handle conflicts among the same?
Yeah. Okay, I think we've already covered that more or less. So you have so much discretion as a settler as to how things you go about it. First of all, a lot of things depend on, for example, how big is your wealth portfolio. If you have a very kind of big portfolio, and things will probably get a little bit complicated, and maybe you don't really have people who have the expertise in terms of your immediate family to take care of that wealth. You probably do want to go for a professional trustee and a professional enforcer. If you have among your friends and relatives people who are competent, maybe they're professionals as well, that's also a good thing to do. You might want to ensure that there's no conflict of interest between your trustees and your beneficiaries. Yeah, what was the second part of the question? I didn't write that down.
How can you handle conflicts among the trustees?
Okay, so I would have wanted to know what kind of conflict. I'm not sure what kind of conflict would come in, because usually conflicts with the beneficiaries, but strictly speaking, they're just there to manage. If they're so okay, this is the right thing to say. Your trust deed will have anticipated the contract will have anticipated any possible conflicts in the future. So there'll be procedures as to what to do. There'll be procedures as to how to dismiss people, procedures as to how to get new trustees. So all of that is in your trust deed. So if you have a well-drafted trust deed, you don't have to worry about what happens. It's very much like a company constitution. You don't have to worry about what happens if something goes wrong, because all the kind of rules and terms and conditions are already drafted in your trust deed. So if you have a well-drafted one, then you don't have to worry about that because it's already in the trust deed. Then you'd already have a kind of a structure of how to go about any challenges or conflicts.
One question from Rehab. What safeguards can be put in place to ensure the trustees don't get greedy? Are they compensated for being trustees?
Yes, I mentioned that earlier. So your trustees are not allowed to earn an income from the trust. That goes without saying. However, you can put in the trust deed and allow them to be able to get reimbursed or to get a sort of like a salary of some sort. So that will already be in your trust deed, which means they cannot be able to go over and above that. That's number one. Then number two, if you get an enforcer comes in every now and then and looks through the trust books to see what's really happening. In terms of where the money is going, what's coming in, what if you have rental income, for example, how much is coming in, where is that going? If it's being reinvested, where is it going? How much is whether the beneficiaries are being given the amount of money that they need for their education, for their hospital bills, whatever it is that they need according to the trust deed. So if you have an enforcer and you have the trust deed that strictly speaking says what it is that they can be able to earn, whether or not they can earn in the first place and what it is they can be able to earn, then you will not have a problem. The problem comes in if the things are vague, if there's a lot of ambiguity. They're given a trust a lot of power, but there's no mechanism, there are no safeguards as to, what it is they can do or what they cannot do.
Can a bank or a financial institution be used as a trustee?
Yes. I mentioned that earlier. You can use them as professional corporate trustees. What we usually do is that we work alongside them to give them legal help and legal advice. But if you, as I said, it very much depends on your wealth portfolio. If you're only thinking about, say, I don't know, 3 pieces of land, shares, maybe it's just your average portfolio. You probably don't want to go for the corporate trustees because they also come with high fees. So you have to think about that. But if you want someone who is impartial, someone who will not be compromised by your beneficiaries, then it is good to go for a corporate trustee.
Thank you. Another question. What costs are incurred when transferring properties to a trust? If real estate, for instance, is stamp duty cost applicable?
No, we said earlier that one of the things is that, so before you even start transferring your property into the trust, you want to get it registered. We said that earlier. So get it registered and incorporated. Once it's registered, then you can be able to to get all the benefits and the perks of having a registered trust. So we said earlier, you benefit from tax breaks like the capital gains tax, the income tax. There were 3 of them. And then if you're a beneficiary, you're also able to get income from up to 10 million. That is going to be income tax and capital gains tax free. With regard to anything that is transferred into the trust, there's a stamp duty exemption. So that's good. Also capital gains tax exemption as well as income tax exemption. So those are the 3 main ones. And as I said, again, when beneficiaries are getting any benefits from the trust up to 10 million a year, that's also exempt from both both income tax and capital gains tax.
What are the potential drawbacks of the trusts and from the same person? Does one have to be filthy rich to get a trust?
So what are the potential drawbacks, you said?
Of the trusts?
Okay. The main one, of course, is the fact that you as a settler, you really do, if you go for the irrevocable trust, you lose a lot, you lose control. You really don't have much power. The other thing is that in the long term, I suppose you do have to think about running costs, which could be more or less the same as if you go for the probate route, but you do have to kind of cater for those costs. However, if you have trustees that do a good job of managing your trust, then you wouldn't have to worry about that because it means that there's income coming in. Whatever money it is they get from their rental properties, from their shares, they're able to reinvest, that's allowed, and they're able to enjoy all these tax breaks. So it is worth it.
So does one have to be filthy rich to get a trust?
Oh, you don't have to be filthy rich. The other good thing is that with trusts, the amount of property and assets you put in at the beginning, you can keep adding to them. So it doesn't mean that just because you put in 2 properties and shares and your rental income, it doesn't mean that is it. Because in the future, you're able to also add more property, add more assets, add more wealth, and kind of keep growing. And then the good thing is that whatever it is that you're able to get in terms of investments, you can then be able to reinvest back into the trust. So that is an advantage.
What are the costs of registering a trust?
Okay. So this varies because obviously the amount of the property, the wealth, the assets vary from person to person. It also depends on whether you want to just have it registered or incorporated. It depends on whether you have property in the country only or abroad. So it really does vary. But we usually we have a very competitive rate. So if you contact me, call me on the number there, or or kind of come to WhatsApp or Telegram, we'll be able to give you a very good rate. But it does vary. So it's very difficult to say, this is the amount. Yeah, but they're competitive rates. You should not worry about that.
A follow-up to the cost of setting up the trust is, so the cost of registration depends on the valuation of one's wealth. Is that the case?
Yes, it does depend on what is, okay, so let me not, that's not strictly true, because there's some standard government fees. So if I can just get that for you. Sorry, I'm not misleading you. Okay, so we have a what we call statutory or government fees. So registration and incorporation is usually 10,000 shillings. Then you have things like name reservation. You have to get a stamp duty on the trust deed. Then you have to get gazettement. So you have this kind of normal statutory fees. So what varies is legal fees, because that very much depends on the complexity of the trust, depends on the number of assets, the value of the assets. And maybe even the conditions. Sometimes you have trusts that have very special conditions and trusts that are very basic, but the statutory fees are the same across the board, as I said. I hope that's clear. Thank you.
Thank you so much, Wambui. That was a wonderful session. We truly appreciate. And I'm sure if more questions come up in future, you can gear us towards a future presentation.
Sure.
Okay, I have seen one last question that has just snuck in. After this, we close. Expound some more on the stamp duty on trust deed. Is it pegged on value of assets in the deed?
Okay, so we're talking about the registration of the trust deed, not the transfer of the property that comes into the trust deed, into the trust. So any registration for anything, whether it's your company constitution, whether it's your transfer of property, the transfer, anything that will usually accrue some stamp duty. So this particular one is very nominal. It's just 2,000 shillings for the trust deed. Yeah, I mean, I can mention it again. So we said the incorporation fee is about 10,000. Then you have the name reservation is about 1,000 shillings. Stamp duty on the trust deed is 2,000 shillings, and then the gazettement is about 5,000 shillings. Those are very nominal. And then, but then you have legal fees with regard to the actual drafting of the trust deed. That's the most complex part of it, really. And then that depends again on the number of the trust, of the number of the assets, the complexity. Of whether, the number of trustees, any special conditions, and all of that.
With that, I will say thank you very much, Wambui. This was a very wonderful and very insightful session. We truly appreciate all that you've done. And I'm sure if you were to bill us, the fee note will be immense. So thank you so much. Truly appreciate.
Yeah. Asante.
Karibu. And as we close, I will repeat my monologue that I was muted on as I was mentioning that. This marks the final presentation in 2025. For Lendi Sana, I was not very good in following up on presentations this year. I will work on that in 2026. We do have our very first presentation of 2026. It's going to be by Dawn Marie, and I will just read her blurb about it. Unlock the power of visibility and influence. Our first webinar for 2026 will be on marketing for professional services, designed specifically for consultants, accountants, lawyers, engineers, and other service professionals. You will discover how to position your expertise, build trusted client relationships, and stand out in a competitive market. We will also share some strategies on personal branding, digital marketing, and client acquisition that drive measurable results. Whether you want to build your personal brand, you are starting out, or scaling your practice, this session will equip you with actionable insights to grow your impact and your income. That is going to be on the Wednesday, the 21st of January 2026 at 8 p.m. Details on that, link to that will be shared in due course. And with that, I'd like to wish you a most wonderful evening and a most wonderful end to your year 2025. We'll see you again in 2026. That is it from the Alliance Alumni Webinar Series. Goodbye and good night.
Thank you.